Welcome back to Protecting Trade Secrets. I'm Professor Seth C. Oranburg. In the previous lecture, we covered the first two elements of the trade secret test: information and independent economic value from secrecy. We saw how courts demand concrete, defined knowledge, not vague concepts or general skill. We explored how economic value must flow specifically from the fact that information is secret, not just from the fact that it's useful. Now we turn to the third element: reasonable efforts to maintain secrecy. This is where most trade secret cases are won or lost. You can have the most valuable novel information in the world, but if you don't treat it as secret, the law won't protect it. Courts don't enforce good intentions. They enforce what actually happened. In this lecture, we'll explore what reasonable efforts really means, why consistency matters more than perfection, and how courts evaluate secrecy measures in practice. We'll look at cases where companies lost protection, not because they were careless, but because they couldn't prove they took their own secrets seriously. By the end, you'll understand that trade secret protection isn't a passive entitlement. It's an active process, and the work begins long before litigation. Let's start with the standard itself. The third element of the trade secret test requires that the owner make reasonable efforts to maintain secrecy. Some states use slightly different language: reasonable measures or reasonable precautions. But the concept is the same. The law does not demand perfection. It demands conduct that is appropriate and proportionate to the circumstances. That word reasonable is doing a lot of work. It's context dependent. What's reasonable for a 10-person startup is different from what's reasonable for a Fortune 500 company. What's reasonable for a manufacturing process that only 3 employees ever see is different from what's reasonable for a customer list that your entire sales force uses daily. Courts evaluate reasonableness on a case-by-case basis. They look at the totality of the circumstances. They ask, given the nature of the information, the structure of the business, and the risks involved, did the company do enough? But there are certain baseline expectations that apply across industries. Courts consistently look for evidence of written confidentiality agreements, access restrictions, document labeling, employee training, and exit procedures. When these foundational measures are missing or inconsistently applied, courts are quick to find that the secrecy element hasn't been met. The key insight is this: reasonable efforts are not about checklists or formalities. They require alignment between what the company says it values and how it actually behaves. Courts reward that alignment. They don't supply it after the fact. Let's look at a case where the absence of basic protections proved fatal. Airfacts, Incorporated versus Amezaga, decided by the Fourth Circuit in 2018. Airfacts was a company that compiled proprietary airline data, information about routes, schedules, and operational metrics. A former employee allegedly took this data after leaving the company and disclosed it to competitors. Airfacts sued for trade secret misappropriation. The court ruled against Airfacts. Why? Because the company had not taken even minimal steps to protect the information. There were no signed non-disclosure agreements with employees. There were no documented access restrictions showing who could view the data and under what conditions. There were no internal protocols indicating that the information was treated as confidential. The company essentially assumed that employees would understand the data was sensitive, but assumption is not enough. The court emphasized that trade secret law requires visible effort. It's not sufficient that information is internal or useful. If the company hasn't documented its protections, defined its expectations, or limited access to those with a need to know, courts will conclude that it forfeited any claim to secrecy, whether intentionally or not. Airfacts illustrates a harsh but important principle. You can't claim trade secret protection after the fact if you didn't act like a trade secret holder beforehand. The absence of NDAs, access logs, and training isn't just a procedural gap, it's evidence that secrecy wasn't real. But what if a company has some protections in place, but applies them inconsistently? That's where things get even more complicated. Consider Allstate Insurance Company versus Fougere, a 2021 case from the District of Massachusetts. Allstate alleged that a former insurance agent took confidential customer information and internal training materials to a competitor. On paper, Allstate had policies protecting this information. but in practice, enforcement was inconsistent. Some materials were shared widely without restriction. Others were marked confidential, but treated casually. Employees had access to information they didn't need. Training on confidentiality was sporadic. The company's own behavior suggested that it wasn't clear about what was actually confidential. The court dismissed parts of the trade secret claim. The reasoning: if the company itself was unclear about what was confidential, how could a third party be expected to understand the boundaries? This case reflects a broader judicial concern. Trade secret law assumes that secrets must be signaled. It's not enough that they're understood internally. They must be actively communicated and enforced. Lapses, ambiguity, or silence create vulnerability, not just to misuse, but to legal failure. Fougere teaches us that consistency matters. Courts look for patterns of behavior, not isolated acts of protection. A company that protects some secrets rigorously, but treats similar information casually, undermines its entire position. Internal contradictions unravel trade secret claims. So what do courts expect to see? Let's break it down into concrete categories. First, written confidentiality agreements. NDAs with employees, contractors, and third parties are the starting point. Courts want to see that people who accessed the information understood, in writing, that it was confidential and that they had obligations not to disclose or misuse it. Verbal understandings aren't enough. Memory fades. People leave. Written agreements create a record. Second, access restrictions. Who had access to the information? Was access limited to those with a legitimate need to know? Were there password protections, locked files, or segmented systems? Courts look for evidence that access wasn't casual or universal. The more sensitive the information, the tighter the restrictions should be. Third, document labeling. Were files marked confidential or proprietary? Courts give weight to visible signals that tell recipients how to treat information. Labeling isn't just bureaucratic. It's communicative. It tells employees, vendors, and partners, this matters. Handle it accordingly. Fourth, employee training. Did the company educate employees about what qualifies as confidential and how to protect it? Training doesn't have to be elaborate, but it should be documented. Courts ask, did employees know their obligations? Were they reminded over time? Was confidentiality part of the onboarding process and reinforced during employment? Fifth, exit procedures. What happened when employees left? Were access credentials revoked? Were devices collected? Were departing employees reminded of their confidentiality obligations in exit interviews? Courts pay close attention to what companies do at the moment of maximum vulnerability, when someone walks out the door with knowledge in their head and files on their laptop. None of these measures alone is determinative. It's the combination, the totality of the circumstances, that matters. But when multiple categories are missing or weakly implemented, courts conclude that secrecy wasn't a priority. Reasonable efforts don't stop at creating policies. Companies must also monitor whether those policies are being followed. Monitoring begins with visibility. You can't protect what you can't see. At a minimum, systems should log access to sensitive materials. Who accessed what, when, and from where. These logs provide the historical record needed to identify patterns, detect anomalies, and, in litigation, prove misappropriation. When a departing employee is suspected of taking trade secrets, access logs can reveal whether confidential files were downloaded in the days before departure, whether external storage devices were connected, or whether login activity occurred outside normal working hours. The presence of these logs can shape litigation. The absence of them can doom a case. Courts don't require every company to have a sophisticated intrusion detection system, but they do expect that sensitive systems are monitored and that unauthorized or suspicious activity triggers investigation. In some cases, the failure to monitor has been cited as evidence that the company didn't genuinely treat the information as a secret. Auditing reinforces these efforts. Regular reviews of access permissions, user activity, and policy compliance help ensure that protection remains effective over time. Audits can identify dormant accounts that still have access, shared passwords, misconfigured permissions, or other silent vulnerabilities. Courts give weight to companies that perform regular internal audits and act on the findings. When a business can show that it reviewed its own systems, updated its controls, and corrected deficiencies, it sends a clear message. Confidentiality wasn't left to chance. No system is perfect. Even companies with strong policies and carefully calibrated controls will sometimes experience loss. A laptop goes missing. A departing employee takes files. A mistake is made, and sensitive information is exposed. When that happens, the question isn't whether the company failed. It's how the company responded. Trade secret law doesn't require absolute prevention. It requires reasonable efforts. That standard allows for the reality that human error, technical breakdowns, and even intentional misconduct can occur despite a company's best intentions. But when safeguards fail, the company must act quickly and deliberately to preserve its legal rights. The most important step after a failure is containment. If a breach is suspected, access must be revoked immediately. Relevant logs should be preserved. Systems should be audited to determine what was taken, when, and by whom. If devices are missing, they should be remotely wiped or deactivated if possible. Investigation follows containment. The company must determine whether the incident involved a trade secret, whether any contractual obligations were breached, and whether the recipient knew or should have known that the information was confidential. This requires both technical analysis and legal evaluation. Documentation is essential. Courts evaluate not just whether a company responded, but whether it can prove what actions it took. The internal investigation should be documented. Communications should be recorded. Decisions about response, notification, and remediation should be tied to the company's broader trade secret protection plan. If the case proceeds to litigation, this record will help establish that the company didn't act out of panic, but instead followed a disciplined approach. Let's recap. The third element, reasonable efforts to maintain secrecy, requires that companies treat their trade secrets like secrets, not just in policy, but in practice, not just at the beginning, but continuously. Courts evaluate this element through the totality of the circumstances. They look for written agreements, access restrictions, document labeling, employee training, exit procedures, monitoring, and auditing. They expect consistency. They reward discipline, and they penalize indifference. In Airfacts, the absence of foundational safeguards was fatal. In Allstate, inconsistent enforcement undermined the claim. Both cases teach the same lesson. Trade secret protection is not a passive entitlement. It's an active process that must be visible, consistent, and sustained. In our next lecture, we'll move from the three-element test into practical application. We'll explore how to inventory trade secrets, how to classify them by sensitivity, and how to design protection plans that actually work in the real world. Thanks for listening. See you in the next lecture.